Hi and welcome to my channel. So today we are going to look at the Advocates Act, and so we'll look at who is qualified to be an advocate, who is an unqualified person, what we need. Okay. Advocates remuneration or payment of fees for their services. The Complaints Commission will look at so many things. Practicing certificates, hearing of complaints. We'll look at offenses, okay, and penalties. We'll look at striking off of advocates, the disciplinary tribunal. Okay, so let's get started. So the first thing I would like to say is that an advocate is defined to be someone who has been admitted, okay, to the role of advocates and has enforced a practicing license. Okay, so he must be someone who has completed the LLB program. Okay, that is the Bachelor of Laws in a university recognized. Okay, in Kenya. He must also have gone through Kenya School of Law. That is a advocates training program, and qualified to sit for the bar exams, have sat for the bar exams, done pupillage, and all those are requirements for being admitted to the role of advocates as an advocate. Okay, so he is admitted as an advocate. His name is on the roll, so he's not been struck off. His name is still on the roll, and another condition is that he has enforced a practicing certificate. All right, so that is section 9 defines who an advocate or a qualified person is. So we move on to, so we have other officers who are appointed by the Attorney General, okay, or the Director of Public Prosecutions, who act as prosecutors. Okay, those are the people who can also act as advocates. Okay, because prosecutors who are appointed by the DPP can be police officers. Sometimes they stand in and they represent, okay, the state in criminal matters as prosecutors. So the principal registrar of titles and any registrar of titles, so anything to do with conveyancing, registrar of titles can appoint people to act as advocates. Any person holding office in a local authority, such other person being a public officer, okay, as appointed by the Attorney General. So those are the few instances where someone who is not an advocate is qualified to act as one. Then we have this provision on foreign advocates, where the Attorney General can admit to practice people who are foreign advocates, okay? So anyone who is an advocate of the High Court of a Commonwealth country, those people can come to Kenya and appear or act or advise in a suit, okay? So no foreign advocate shall be entitled to practice until he has paid to the registrar the fees, the admission fee. No foreign advocate shall be entitled to practice unless he is instructed, and if appearing in court appears with an advocate or any person mentioned in section 10, nor shall any foreign advocate be entitled to sign or file any pleadings in court. So the person can appear upon paying a fee to the registrar of the High Court. He will also be not able to sign any pleadings in his name or the name of the firm he represents. Okay, he just enters appearance, he can advise, he can appear, he can represent. Okay, all right. Now, where a foreign advocate has been found to have violated any rule of conduct for advocates, where he is found to have uh, where he's been complained against or a complaint has been filed against him to the complaints commission, he will be suspended. Okay, through by the chief justice. Now moving on, admission as an advocate. So we have another section 12 which also talks about qualification for admission as an advocate. So not just anyone can be qualified to be admitted as an advocate. You need to have done a Bachelor of Laws degree, graduated from a recognized university in Kenya, and if it's foreign, it should be certified by the CLE, Council of Legal Education. Also, you need to have gone through Kenya School of Law, ATP training, advocate training program for 18 months, and graduate and done and sat for the bar exams, passed the bar exams, gone through pupillage and complied with pupillage. Then you have the compliance certificate, and you're admitted. You petition the Chief Justice to um, to admit you to the role of advocates. Okay, so subject to this act, no person shall be admitted as an advocate unless he's a citizen of Kenya, Rwanda, Burundi, Uganda, or Tanzania. So we have the East African countries here being those that can allow, okay, citizens from those areas to come and be admitted as an advocate in Kenya. He is duly qualified in accordance with Section 13. So let's see. Professional and academic qualifications under Section 13. A person shall be duly qualified if having passed the relevant examinations of any recognized university in Kenya, he holds is eligible for conferment of a degree in law, and then has passed the relevant Kenya School of Law, sat for the bar exams by CLE, and all those other requirements I talked about. Okay, so pupillage is also a requirement. You can't be admitted without it. So you must be a pupil for 6 to 7 months. That will be in a law firm or any other certified center you can take that has been allowed or permitted as to have your pupillage at. You have to pass the exams, the bar exams by Council of Legal Education. You also must possess uh, you must possess any other qualifications CLE requires, must be, you know, an advocate also for the time being. In other cases where we have people from East Africa, so you are admitted where you are currently an advocate in Uganda or Rwanda or Burundi or Tanzania, or you are admitted as an advocate of the Superior Court of any Commonwealth country, that is United Kingdom, for example, has practiced in that country for a period not less than 5 years, and is a member of good standing in a professional body. So you can see that this section 13 contains all the professional academic qualifications, and these qualifications also have been set for foreign advocates in Commonwealth countries who have to be uh, um, have to have been an advocate for 5 years or more, or is and as well the member of a professional body in that country. Uh, Also, those foreign advocates will be required to undergo extra training for a period not more than 3 months, as the council may prescribe for the purpose of adapting to the practice of law in Kenya. So you can see that in order to be an advocate uh, in Kenya, if you are from United Kingdom, for example, you need to be an advocate to have already been admitted as an advocate there and have practiced for like 5 years or more, and you're a member of a professional body there in your country. Then upon coming, you are required to take some kind of training for 3 months, which the Council of Legal Education will prescribe. So you can adapt, of course, to the environment, the legal environment here. So Council of Legal Education may exempt any person from any or all of the requirements prescribed for the purpose upon such conditions if the council may impose. So the Council of Legal Education has discretion to exempt any person from any such requirement as he deems will, as he so wishes, as it so wishes. So we move on to section 14. Attorney General and the Director of and the DPP may take pupils. So yeah, right now it's the season for application for privilege. We have been applying to the Office of the Attorney General. I have not seen the Director of Public Prosecutions advertisement, but these offices are required to take on pupils. They take, I think, a maximum of 50 pupils per year, every year, I think, if I'm not wrong. Um, yeah, so yeah, that is what they do. Section 15, admission as an advocate. Every person who is duly qualified in Part 13 is entitled to be admitted, may apply to be admitted to the role of advocates. The application will be made by petition. So there's normally a petition that you petition the Chief Justice, telling him how you have complied, telling how is it telling her how you have complied with all the requirements under Section 13, professional and academic, and how you have your you have your certificate of compliance from Kenya School of Law for privilege, from and then your witness whatever's from some advocates of I don't know how many experiences, 5 years or more. So you have all this, you petition, like, okay, it's not a guarantee you're going to get, but unless somebody is going to object to your being admitted, but you apply, it's not automatic. You have to petition with its accompanying documents and evidence. All right. So the application is made to the Council of Legal Education Secretary and the Secretary of the Law Society of Kenya. All right, so yeah, so that is what you do. You swear an oath. Every petition made under this section shall be heard by the Chief Justice in chambers, okay, within 90 days of the expiry of the period. And the Council of Legal Education and the society shall have the right to be heard. So the Council of Legal Education, which administers the bar exams, as well as the Law Society of Kenya, will be heard, okay, if they have any evidence to object your admission. If maybe you've been found wanting in any area, maybe you have a criminal record, I don't know. So whatever happens, happens. Also, your morality plays a big part. Maybe you are not representing the nobleness of the career. Maybe on your social media account, you've been doing some things there that are not up to par with the legal profession. and the nobility and whatever crap it represents. I'm sorry. Okay, so it's all about ethics and everything. Okay. 90 days. Now, moving on an order being made under Section 3 after payment by the petitioner. So there's also a fee that you pay. The petitioner shall take an oath or make an affirmation as an officer of the court before the Chief Justice, and shall therefore sign the roll in the presence of the registrar or a deputy registrar, who shall add his signature as witness. So the whole process of admission of an advocate is bureaucratic, to say the least. There is like a whole process that you need to follow, like an initiation or something like that. So yeah, if you're not into rules or initiation processes, whatever, this career may not be for you. All reports, records, and communications made under or in connection with this section shall be absolutely privileged. So, custody of law, section 16, the registrar shall keep the role of advocates in accordance with this act and any direction. So, it's the registrar of the High Court. Now, senior counsel, 17, section 17. The president may grant a letter of confinement to any person of irreproachable professional conduct who has rendered exemplary service to the legal and public service in Kenya, conferring upon him the rank and dignity of senior counsel. So a person shall not be eligible to be a senior counsel unless he is duly enrolled advocate of the High Court of not less than 15 years standing, or being a person to whom Section 10 applies, he holds and has held for a continuous period of not less than 15 years one or other of the qualifications specified in Section 13.1. The grant shall be made not less than 60 days upon receipt of a list of names submitted by the Committee on Senior Counsel through the Chief Justice. All right. So we have a committee that submits names of advocates who have 15 years experience and more, and who have contributed to maybe the jurisprudence in Kenya. They have they represent some high profile cases, maybe of essence to the country and public interest. So there must be some contribution here, exemplary service, okay, on their part. All right, so you can see this is quite interesting. Now, so there's a hierarchy here. You can already see not all advocates will be the same. There's a hierarchy of advocates. So being the noble career that it is, the prestige and blah, blah, you can imagine not everyone is going to be the same, okay? We are going to have people who are better than others by virtue of their experience in the field, okay? Now, Section 18, role of senior counsel. Upon the commencement of this act, the registrar shall cause to be prepared and shall therefore maintain a role of advocates having the rank of the senior counsel. So there's also the role of senior counsel, apparently, which is different from the ordinary role of advocates. All right. So Section 19, application of Part 9. In the application, senior counsel, all reference that therein to the legislation shall be construed as given to a committee of 3 to be appointed in each case by the Chief Justice, consisting of the Attorney General or the Solicitor General and 2 senior counsel. So the committee I told you about, which normally submits the names to the Chief Justice for admission as senior counsels, is made up of the chief, okay, to be appointed in each. It consists of the Attorney General or the Solicitor General and 2 senior counsel. Okay. The secretary to shall perform the duties of secretary to any such committee. So the secretary of the disciplinary committee is going to be also acting as a secretary in this committee. Now moving on, Section 20 precedence, the Attorney General, Director of Public Prosecutions, the Solicitor General, Senior Counsel, and Queen's Counsel according to the date of their appointment as such, the Chairman, the Vice Chairman, if not a Senior Counsel of the society shall in that order take precedence of advocates who shall take precedence according to the day. I don't understand. We don't have a queen. Moving on, part 7, practicing certificate. Section 21, register to issue practicing certificate. So the registrar shall issue in accordance with but subject to this part and any rules made under this certificates authorizing the advocates into practice. So we have practicing certificates that are issued by the registrar. Okay. Application for an issue of practicing certificate. How do you apply for a practicing certificate? Application for a practicing certificate shall be made to the registrar by delivering to him an application in duplicate signed by the applicant, specifying his name and place of business. So you must apply in duplicate, you sign, specify your name and place of business, and your date of admission as an advocate. By producing evidence satisfactory to the registrar that the applicant has paid to the society the fee prescribed. So there's a fee. I don't know if it's 30,000. I don't know if that amount has increased, but it's not free. You pay to have your practicing license granted to you and to renew it every year. Okay. Okay. So there's an advocates benevolent association also, and by producing a written approval signed by the chairman of the society stating that there's no objection to the grant of the certificate. So it's everything is quite a process. It's not automatic. Being admitted is not automatic. Being granted the certificate also requires application and proof. Okay. Now, subject to section 31. The registrar is certified that the name of the applicant is on the roll and that he is known for the time being suspended from practice shall within 14 days of the receipt by him of the application issue to the applicant a practicing certificate. So it takes 14 days. The registrar shall cause one copy of each declaration delivered to him under this section to be filed in a register kept for that purpose. And anyone can inspect the register. Okay, for free. Now, section 23, issue of practicing certificate to confirm membership of society. Every advocate to whom a practicing certificate is issued will become a member of the Law Society of Kenya. They will automatically be considered members of the Law Society of Kenya. And as well, become a member of the Advocates Benevolent Association, and they are the rules that govern the organization will govern the advocate, okay, as a member. Every advocate who's become a member of society and this shall remain a member until the end of 1 month after expiration of his practicing certificate. So being a member goes hand in hand with the renewal of your practicing license. So your practicing certificate is renewable annually every year, and 1 month you get 1 extra month, okay, before after your license expires, and of course as you apply for another to be still a member of the society. All right. The society shall issue to every advocate registered with it a stamp or seal bearing the advocate's name. So those stamps of the advocates, you don't manufacture them. You don't just make them by yourself. It is given to you by the Law Society of Kenya. So you can see how the Law Society of Kenya is is holding the key or the reins or the ropes of advocates all over the country for as long as they wish to practice or be advocates. They will need to be members of the society. Okay, if you want to represent someone in court, you need to have a current practicing certificate. If you want to sign any pleadings, conveyances, you need to have a current practicing license. So you understand how LSK is like this monopoly or the king of advocates, because without membership to the society, you don't have a stamp and you don't have your practicing certificate, which means that you can't work, you can't represent people, you can't sign pleadings, okay, you can't stamp those documents. So you understand how this is interesting. And of course, if you before, in the case, there was a case of Ndolo versus National Bank of Kenya, I think, where the person had, where an advocate had stamped conveyance instruments without a charge. I think it was a charge instrument um, what do you call, without having a current practicing license. It was declared a nullity, okay, that it wasn't, the instrument was null and void ab initio, okay. But you see that in another case, Anwaj warehousing, I think, versus the National Bank of Kenya, we have that the person tried to claim the same, that the advocate for the bank, for the chargee, had signed or executed the document, the instrument, without having a current practicing license. So it was null and void ab initio, but the jurisprudence has changed. Now, if you are the court held in that case that if you are an advocate who has executed a document, but you don't have a current practicing license, that doesn't mean the instrument was null and void, because by virtue of the Advocates Act, you are still an advocate. You've been admitted, your name is on the roll, but there's some conflict between Section 9, which requires a current practicing certificate, and other sections like Section 13, which has all these other qualifications and professional and academic. So there's no harmonization as to qualification of an advocate, and the court ordered that the act be amended to harmonize the qualification of who really is qualified, who is a qualified person, who is an advocate, and the effect of the instrument signed by those people, and the effect of instruments signed by total lay persons who may be accountants or some other masquerading persons, laymen who are not advocates. So in this case, the court held that, of course, he was an advocate, that the instrument was valid and was standing. There's no way Anwaj Warehousing was going to say that the charge instrument was void, to avoid paying up, or to avoid having his property sold. So in this case, it's very clear that an advocate is an advocate. The practicing license under Section 9, current practicing license, does not mean that if you don't have it, then you are just as well like any other lay person out there. No, you're an advocate, but that doesn't mean that you will go scot-free for signing documents that with a stamp without the current practicing license. That means that you must be punished, okay? You will face professional misconduct, a charge of professional misconduct, okay? And you can be taken before the Complaints Commission and penalized for the action that you have done, okay, of signing without having a current practicing license, conveyance instruments or conveyances. So you can imagine what this is all about, yeah? So there's been some change, but the act is sleeping and requires some form of amendment, okay, harmonization or updates to keep it up to date with the current jurisprudence. So moving on, section 24, date and validity of practicing certificate. Every practicing certificate shall bear the date of the day on which it is issued and shall have effect from the beginning of that day, provided that a practicing certificate which is issued during the first month of any practicing year shall have effect for all purposes from the beginning of that month. Okay, so this is common knowledge, but let's just see. The pricing year shall be from 1st January to 31st December, provided that the Council of the Society, with the approval of the Chief Justice, may by order alter the pricing year, and the order may make such transitional provision with regard to incidental matters as may be expedient. So you can see very clearly here that the Council of the Society of, that is the Law Society of Kenya, can alter this practicing here. It can start wherever they plan, and the order may make such transition provision in regard to, okay. So the LSK here is the one that runs the show, okay, of practicing certificate, as well as the Chief Justice. Together they can just decide to change the year from January to start July or June, okay, for whatever they wish. Every practicing certificate shall expire at the end of the 31st December, provided that where the name of an advocate is removed or struck off the roll, the pricing certificate shall expire forthwith. So if you are struck off the roll of advocates, maybe because uh, you have acted or violated the standard, the code of conduct and standards of practice for advocates. You have been taken before a complaints commission, you've been referred to the disciplinary tribunal facing your charges, and they have decided your penalty is being struck off the advocate's roll, then of course your practicing license is ineffective, okay? Suo motu. The registrar shall enter upon the roll a note of the date of the issue of every practicing certificate. Now, section 25, discretion of registrar to issue pricing certificate in special cases. So the registrar has a discretion to issue exemplary or exemplary certificates, price certificates in special cases. Mhm. Okay. So there are special circumstances where the registrar can give, can issue special license, can issue practicing certificates, okay, in special cases where, for example, an advocate is declared bankrupt, where he didn't have a pricing certificate in force after he was admitted, where he has been, where he has not paid penalty or costs to the disciplinary committee, where judgment has been entered against him. Okay. So the registrar can grant or refuse an application in those situations, or decide to issue on conditions, to issue the certificate on conditions, okay? So that is what we need to know. Moving on. where a practicing certificate, okay, that is just too long. Moving to section 10.6, appeals in connection with issue of practicing certificate. The registrar on an application duly made to him refuses or neglects to issue a practicing certificate. The applicant can apply to the Chief Justice, who can make such an order as he thinks fit. Okay, So the Chief Justice is the person you can run to when you have been denied your practicing certificate by the registrar. And he can either uphold the decision or vary it. He can just do anything. Now, Section 27, suspension of practicing certificate in certain circumstances. The making by the disciplinary committee or court of an order suspending an advocate from practice shall operate, and the adjudication in bankruptcy of an advocate shall operate immediately to suspend any practicing certificate of that advocate. So if you are declared bankrupt by a court of law as an advocate, your practicing certificate is frozen or is suspended. Also, if you've been complained against and you've been charged, and the penalty is to suspend maybe your practicing license for 6 months or 1 year, then that is what will happen. It becomes effective immediately. Section 28, duration of suspension of practicing certificate. Subject to this section, where a practicing certificate has become suspended by an order under section 24, 26, or by violation 27, the suspension shall continue, this certificate expires. So the suspension continues until the certificate expires. So if it's like 2 months to go, 1 month to go, that is what happens. The advocate can, at any time before the certificate expires, apply to the registrar to terminate the suspension. So you have a recourse where you're declared bankrupt or when an order is passed against you. You can appeal to the registrar to have the suspension ceased or terminated, and you give the notice to the secretary of the law society of your application. So you can challenge your suspension with the registrar. The council of the society may make representations or submit recommendations to the registrar with respect to any application made under this section. And the representation recommendation shall be absolutely privileged. The registrar now, upon his discretion, can either terminate the suspension or refuse the application, okay, of termination and allow the suspension. If on an application by an advocate under subsection 3, the registrar refuses the application or terminates the suspension, okay, but the advocate by petition presented in such manner may go to the Chief Justice. Now you can see here there's a certain hierarchy. The Chief Justice is your father, the one that you will need to go to every time where your brothers, the LSK, and the registrar do anything to you, okay? That is unjust. You have the right of recourse, and that I think your father is the father, okay? Is the highest hierarchy here. The Chief Justice is the person you will go to by petition. So Chief Justice is approached through a petition. If you are aggrieved, we have seen it. So you go through by way of petition to the Chief Justice, and then you challenge the decision by the registrar and the Law Society of Kenya and the disciplinary tribunal. So the Chief Justice now can either affirm the decision or terminate the suspension. Okay. publication of suspension or termination of suspension or practicing certificate. When advocate's practicing certificate has been suspended, where maybe he is complained against and an orders passed, or where he was adjudged bankrupt, the registrar can cause that notice of suspension to be published in the Gazette so everyone can know, okay? And a note of suspension entered on his name on the roll of advocates, okay, where so, and where the person's order of suspension was seized or terminated, the same note can be indicated next to his name on the roll of advocates or be published in the Gazette. Now, Section 30, evidence as to holding of practicing certificate. Any list purporting to be published by authority of the registrar and to contain names of advocates who have obtained practicing certificate for the current year before 1st February shall, until the contrary is proved, be evidence that the persons named therein as advocates holding such certificates as aforesaid for the current year are advocates holding such certificates. Okay, so any evidence held by the registrar of people about their pricing certificate status is what is held as true. The absence from any such list of any name of person is evidence that the person is not qualified to practice as an advocate under a certificate for the current year, but in the case of any such person, an extract from the roll certified as correct by the registrar shall be evidence of the facts. So it's the role held by the practicing certificate uh, register held by the registrar is prima facie evidence that the person, the information there is true to the person. Okay, and if you claim otherwise, you have to discharge that proof. You have to prove. Okay, you have to prove your claim. Moving on, provisions with respect to unqualified persons acting as advocates and offenses by advocates. Okay, so we have section 31. Section 31, subject to section 83, no unqualified person shall act as an advocate or as such cause any summons or other process to issue. So unqualified people cannot act as advocates. You cannot issue summons. You cannot institute proceedings in any court, criminal, civil. You cannot carry on or defend a suit in the name of any person. You cannot, basically, you just cannot sign pleadings. You can't execute conveyances. You can't do these things. So, any person who contravenes subsection 1 shall be deemed to be in contempt of court in which he so acts or in which the suit or matter in relation to which he so acts is brought or taken. So you will be held in contempt, okay, by the court and will be punished, be incapable of maintaining any suit for any cause in respect of anything done by him. So you can't claim costs if you act and you're not qualified. You can't claim costs for you to be paid fees for what the service you render. Okay, section 32A, employment as in-house. So we have other types of advocates called in-house counsel. These advocates are those that are employed by employers long-term to serve them, to represent their cases, okay? For example of this can be family lawyers, okay? Can be lawyers that are employed by organizations, lawyers employed by politicians, lawyers employed, I don't know, just employed. So a person who is employed as an in-house counsel or advocate shall be independent. So you have to be independent and you must not, the rules about payment of your fees, the rules about the standards of practice, they still apply to you. Just because you are not in private practice doesn't mean all these rules you are exempted. No, you still become independent. Even if you're employed, you act in your advisory capacity. You charge the same fees for services that are in the remuneration order, okay, of advocate. If it's a letter writing, for example, it says portfolio is 200 shillings, then portfolio is 200 shillings. If it is attendance in court for a full day is 15,000, for a full day then it's 15,000. If you are traveling on their behalf, for that takes a journey that takes like 3 hours, then every hour is 2,500. The same applies, just in the remuneration order. Moving on, section 32b, standards of work and remuneration. The Chief Justice, on recommendation of the Council of Law Society, can prescribe standards of work that may be performed by a person employed as in-house advocate. So I don't know really. Do they have like a different standards of work? But I will look at this. Let me just note it down. Standard of work. So yeah, standards of work and practice, criteria for uh, remuneration for in-house counsel. Okay, so that is that. Uh, so the employer of an in-house counsel shall not determine remuneration otherwise than in accordance with this criteria. Also, the employer of an in-house can give more money but not less than what is in the remuneration order. A person who contravenes commits an offense. Now, penalty for pretending to be an advocate. So, I don't know when I saw a charge sheet where several people were seen masquerading as advocates, and they were charged with the offense of masquerading as advocates. Okay. Now, section 33, penalty for pretending. What is the punishment for pretending to be an advocate? Any unqualified person who willfully pretends to be or takes or uses any name, title, addition, or description implying that he is qualified or recognized by law as qualified to act shall be guilty of an offense. So this is criminal. You can be charged you can be charged for masquerading. Okay. I will look at the penal code and see which offense that is, but it's not closed. So that, let me just note that down. Offense of masquerading. Offense of masquerading as advocate. Okay. Penal code. Okay, moving on. Section 34, unqualified person not to prepare certain documents or instruments. So no unqualified person shall either directly or indirectly through someone take instructions or draw or prepare any document or instrument relating to the conveyancing of property. So you can't draft any conveyance You can't uh, you can't register or form any limited liability company, whether private or public. So you can't form a company or for or in relation to an agreement of partnership or the dissolution. So you can't prepare or draft any agreement of partnership or the dissolution for the purpose of filing or opposing a grant of property or letters. You can't uh, you can't oppose a grant of property or letters for which a fee is prescribed in any order made by Chief Justice relating to any other legal proceedings. Nor shall any person accept or receive directly or indirectly any fee, gain, or reward for the taking of any such instruction or for the drawing or preparation of any such document or instrument. So you see that you cannot, as an unqualified person, uh, draft these instruments of conveyance. You cannot draw, prepare, or take instructions for opposing anything in court. You can't do any such agreement of partnership or dissolution. You can't form a company. Yeah, so provided that this subsection shall not apply to any public officer drawing or preparing documents or instruments in the course of his duty, any person employed by an advocate and acting within the scope of that employment, or any person employed merely to engross any document or instrument. So, thankfully, pupils who are employed by advocates, okay, they can, if they can draft, because imagine if a pupil was uh, was forbidden to draft this, how else will we learn, to do all this? But any person employed by an advocate can do these things and acting within the scope of that employment. Any money received by an unqualified person in contravention of this section may be recovered by the person by whom the same was paid as a civil debt. Any person who contravenes subsection 1 shall be guilty of an offense. This section shall not apply to a will or other testamentary document, instrument, or a transfer of stock or shares containing no trust or limitation. Yeah. Now, moving on, section 34A, additional endorsement. Subject to section 10, an advocate who holds a current practice license shall not file any legal documents in any registry under any law which requires filing of such document by an advocate, or issue such document for any other professional purpose, unless there is affixed on each document the stamp or seal issued by the society. So, filing of documents, you must stamp the pleadings you file in court. You must stamp all those instruments you execute, okay? Now, section 34B, validity of legal documents. A practicing advocate is not exempt under section 10, and who fails to take out a practicing certificate in any year commits an act of professional misconduct. Yeah, so as an advocate, it amounts to professional misconduct if you don't take renew your practicing license. Notwithstanding any other provisions of this act, nothing shall affect the validity of any legal document drawn or prepared by an advocate without a valid practicing certificate. Yeah, so This is the amendment I was talking to you about. Under 34B, validity of legal documents. So if an advocate were to execute and stamp documents uh, when he doesn't have a renewed or a current practicing certificate, it amounts to professional misconduct. Okay, it's an act of professional misconduct. It is not a bar to the validity of the document. So the document is valid so long as he's an advocate admitted and is on his name is currently on the roll of advocate. Okay, just the fact that he did not he did not have a current practicing is an act of professional misconduct. It doesn't mean he is he's a lay person just like everyone else. Okay, no. For the purpose of this section, legal document includes pleadings, so that is claims, petition, claims, applications that are notice of motion, applications originating summons, originating summons, all those things, yeah. It also includes affidavits that are sworn, okay, depositions, all right, applications, mm, deeds and other related instruments filed in any registry under any law. Section 5, instrument to be endorsed with name and address of drawer. So every instrument, every pleading, every application must be endorsed with the name of the person who has drawn. That is why down there, after you've written in a plaint, you've drafted, you write drawn and filed by Gadamfar and Company Advocates, Ecobank Towers, 13th floor, Kimathi Street, Nairobi, PO Box, this. Okay, you must. Okay, and then you don't. The exception is that if you are a pupil working for an advocate, okay, you don't write drawn and filed by you, or you take because you don't have a stamp, you don't have a practicing certificate, so you will draft but you don't say drawn and filed by. That one is gonna be done by the advocate, and he'll include the name of the firm. The Now section 36, undercutting. Undercutting. Any advocate who holds himself out or allows himself to be held out, directly or indirectly, and whether or not by name, as being prepared to do professional business at less than the remuneration order, okay, is guilty of an offense. So we are not allowed to undercut. You can't attract customers by saying that you are willing to charge 100 for letters when it says 200 or 300. You can't say that you are willing to cut down the cost of traveling from 15,000 for a full day to, let's say, 5,000. No, it's not allowed. No advocate shall charge or accept otherwise than in part payment any fee or other consideration in respect of professional business, which is less than the remuneration prescribed. All right. So it's very clear. Section 37, sharing profits. Any advocate who agrees to share his profit in respect of any professional business, whether contentious or non-contentious, with any person, not being an advocate or other duly qualified legal practitioner, shall be guilty of an offense. So you cannot share profits with someone who is not an advocate or a qualified legal practitioner, a counsel. Uh, Provided that the same shall not apply to the payment of any bonus to any of his employees by an advocate being a bonus based or calculated on the advocate's total earnings or profit in respect of any period. Section 38, touting. Any unqualified person who, in consideration of any payment or other advantage to himself or any person, procures or attempts to procure clients for an advocate, okay, in exchange for money, okay, or a commission, is guilty of an offense. Okay, so an advocate is not allowed to employ or commission a tout to go out there and give him clients. Now, section 39, advocate not to act as agent for unqualified person. So, any advocate who acts as agent in any suit or in any matter in bankruptcy for any unqualified person or permits his name or that of any firm of which he is affiliated to be made use of in any such suit or matter upon the account or for the profit of any unqualified person who or who does any other act enabling an unqualified person to appear, act, or practice in any respect as an advocate in such suit or matter, or who assists any unqualified person in any cause or matter in which he knows that such person is contravening or intends to contravene, this act shall be guilty of an offense. Okay, so you cannot act as an agent for an unqualified person. You can't give them your stamp so they start doing up things and representing themselves in your name. You will be guilty of an offense. Section 40, no cost recoverable where unqualified person acts as advocate. So we see here that no cost in respect of anything done by an unqualified person in contravention of this part shall be recoverable in any suit or matter by any person. Yeah, the penalty is you can't claim any fees for any work done. Okay, if you are unqualified. Now, section 41. This validity. That's okay. So section 41, employment by advocate of person struck off their role or suspended. So no advocate is allowed to employ someone who is struck off the role without the written permission of the law society, which may be given for such period and subject to such conditions as the council thinks fit. An advocate aggrieved by the refusal of the council to grant permission for his employment by another is can appeal to the Chief Justice, the father, who may confirm the refusal or allow the employment on conditions. Now, section 42, penalty for failure to disclose fact of having been struck off. So where any person hides the fact that their name has been removed from the role of advocates, okay, uh, so any person who hides the fact that they have been struck off the role of advocates and accepts employment, okay, or seeks employment by an advocate and doesn't inform him that he is not qualified shall be guilty of an offense and liable to a fine not exceeding 50,000 shillings. So if you hide the fact that you are not qualified to practice because your name has been struck off the roll, and you seek employment in a law firm, okay, and you don't disclose that fact, you are going to be penalized by a fine of 50,000 shillings or to imprisonment for a term not exceeding 2 years or to both. Now, it's serious. Section 43, offences by bodies corporate. If any act is done by a body corporate or by any director, officer, or servant of such a nature or in such a manner as to be calculated to imply that the body corporate is qualified or recognized by law as qualified to act as an advocate, the body corporate shall be guilty of an offence and liable to a fine not exceeding 50,000 shillings for each offence. And in the case of an act done by any director, officer, or servant of the corporation, without prejudice to the liability of the corporation, be guilty of an offence and liable to a fine not exceeding 25,000 shillings for each offence. So where a business masquerades as a law firm, for example, and represents clients and receives this, they can be penalized. They are guilty of an offence and they are liable to pay a fine of 50,000 for each offence or 25,000 where it is a person or an officer or a servant of the business who masquerades, okay? In this part, references to unqualified persons and to persons include references to bodies corporates. Now, remuneration of advocates. I told you that advocates are paid according to a remuneration order. They are not just coming up with any fees. They can't charge lower than what is on the order, and they can't charge higher than what is on the order. So, Section 44, Chief Justice may make orders prescribing remuneration. The Council of the Society may make recommendations to Chief Justice on all matters relating to the remuneration of advocates, and the Chief Justice, having considered the same, may by order prescribe and regulate in such manner as he thinks fit the remuneration of advocates in respect of all business, whether contentious or non-contentious. An order made under this section in respect of non-contentious business as regards the mode of payment, prescribe that it shall be according to a scale of rates of commission or percentage, varying or not in different classes of business or by a gross sum or by a fixed sum for each document prepared or perused. Like for example, where you are an advocate and you receive letters from your clients, just please go through these letters, explain to me what they mean or what does this mean. So that is like, I think it's 200 shillings if I'm not wrong, where you peruse and where you write or draft letters. It's like 100 shillings per folio, for example. So they have those rates. They don't just, you know, yeah, they have rates here. So the position of the party for whom the advocate is concerned, the business, that is whether it's vendor or purchaser, lessor or lessee, mortgagor or mortgagee. Yeah, so I have the order here of remuneration examples. Let me give you. In the advocate's remuneration order, a letter that you draft is 300 shillings or 100 or 200 shillings per folio. Okay, folio is 100 words approximately. Receiving and perusing letters is 150 per folio, is 70. Legal opinion, not less than 35,000, which really surprised me because apparently, of course, you have to do your research and everything in order to give opinion, and I think that is the reason why. Journey, if you go on a journey from your place on behalf of your clients to maybe attend court, that is a 7-hour journey or more, is 15,000. Less than 7 hours is 2,500 per hour. Attendance when you attend court is like 1,000 a day. When you go to court offices, registry and what, 500. Attend hearing is half day is like 5,000 to 7,000. Full day 10,000, 15,000. So they have everything here. Service of by process server, yeah, they are paid 1,400 to serve summons, and their meals and traveling expense will be the actual amount in card. Service by post, substituted service, actual expense. When you draft a decree is 1,000. Filing the decree is 300. Attending court to peruse order is 300. Filing applications, notice of motion, those chamber summons, 3,000 shillings. Yeah, so you can see that everything is well provided. There are no mistakes here. Nothing is being left out. Alright, which is very interesting if you ask me, because this means that everyone has their everyone has the same, okay? Everyone has the same fees as long as you're acting for that client in that capacity. So advocates are allowed to take pay monies from their clients as security for their payment, and that is deposited in the client's account. You are not supposed to do anything with that money for personal use. All right. So don't think about it. They're taking money from his clients of security for payments of any remuneration to be ascertained by taxation, otherwise which may become due to him. The allowance of interest, so long as an order made under this section in respect of non-contentious businesses and operation, taxation of bills of cost of advocates in respect of non-contentious business shall, subject to section 45, be regulated by that order. So even bills of cost, taxation of bills of cost, the registrar or deputy registrar who peruses or receives the bills of cost for taxation will refer to the order, the remuneration order. Moving on. When are we finishing? Let me just see. The last section is which section? My God, we're gonna be here for some time. So 86 is the last, and we are at 45. We need to go quickly because there's so many other things we need to go through. So section 45, agreements with respect to remuneration, subject to section 46, and whether or not an order is in force, okay? Under section 44, an advocate and his client may, before, after, or in the course of any contentious business, make an agreement fixing the amount of the advocate's remuneration in respect thereof. So, good news is that you can agree with your client before, after, or in the course of any contentious business, preferably before, make an agreement fixing the amount of the advocate's remuneration in respect thereof, before, after, or in the course of any contentious business in a civil court, make an agreement fixing the amount of the advocate's instruction fee in respect thereof, or his fees for appearing in court, before, after, or in the course of any proceedings in a criminal court or a court martial, make an agreement fixing the amount of the advocate's fee for the conduct thereof, and such agreement shall be valid and binding on the parties provided it is in writing and signed by the client or his agent duly authorized in that behalf. So the section 45 allows the advocates to come into agreement with the client about costs, and that agreement must be in writing and signed by the client or his agent. A client may apply by chamber summons to the court to have the agreement set aside or varied on the grounds that it is harsh and unconscionable, exorbitant, or unreasonable, and every such application shall be heard before a judge sitting with two assessors, who shall be advocates of not less than 5 years' standing, appointed by the registrar, after consultation with the chairman of the society for each application, and on any such application, the court whose decision shall be final shall have power to order that the agreement be upheld or set aside, or that the agreement be varied by substituting the amount with another. Okay, that the agreement be set aside, that the costs in question be taxed by the registrar. Okay, so if as a client you agree to enter an agreement with your advocate and to pay certain amounts, okay, and then you feel aggrieved by that agreement, mostly after you've lost the case. Advocates are not paid. Our lecturer told us advocates, we conduct business, we not on condition that if we win, you pay us, and if we don't win the case for you, then it's the end. No, because otherwise we would not be paid, mostly because not every time do you like win a case. So in this case, it's best to make clients understand that whether or not you are going to win the case for them, you are still entitled to payment, just because by virtue that you worked hard, you represented them, you did your research, of course, and the matter, of course, which you took up was in your expertise and competence. Within your area of expertise and competence, you worked for it, you did your research, you drafted pleadings, you served, you filed, all those things, yeah, you attended court, all those things, that is your energy, your time, your expertise, which you have used to the best of your ability. Okay, you are entitled to be paid. So any client who feels aggrieved by the agreement they have entered into with the advocate for payment can go to court and by way of chamber summons and have the agreement set aside or varied on the grounds that it's harsh, unconscionable, exorbitant, unreasonable, and every such application shall be heard before a judge sitting with two assessors. The assessors are advocates of 5 years' experience or more, and of course, the registrar also, who is in charge of taxation, shall also tax. One of the orders the court can give is to have the costs be taxed by the registrar, who will also either reduce the costs if they are too high, because they'll be referring to the remuneration and common sense. Now, an application as Section 2 may be made within 1 year after the making of the agreement, or within 3 months after demand in writing by the advocate for payment under the agreement by way of rendering a fee note, or otherwise, whichever is the later. So, the client can make that application to escape payment 3 months after 3 months, within 3 months after the advocate has issued the fee note demanding payment, yeah, or within 1 year uh, after it was made. Now, an agreement made by virtue of this section, if made in respect of contentious business, shall not affect the amount of or any rights or remedies for the recovery of any cost payable by the client to any person other than the advocate, and that person may, unless he has otherwise agreed, require any such costs to be taxed according to the rules for the term being enforced with the taxation thereof, provided that any such agreement shall be produced on demand to a taxing officer, and the client shall not be entitled to recover from any other person under any order for the payment of any cost to which the agreement relates more than the amount payable by him. All right, so we have any third parties will not be affected by the setting aside of this agreement, okay, of payment. So where any agreement made by virtue of the same is made by the client as the guardian or committee of or trustee under deed or will for any person whose property will be chargeable with the whole or any part of the amount payable under the agreement, the advocate shall before payment is accepted or demanded in any event within 6 months, apply by chamber summons to the court for approval of such agreement, and every such application shall be dealt with in accordance with subsection 2. Yeah, so the advocates can also move to by way of chamber summons within 6 months to uh, may move to court to approve an agreement, okay, that is made where a person is acting as a next friend for someone or trustee, okay, under a deed or will. If after an advocate has performed part of any of the business to which any agreement made by virtue of this section relates, the advocate dies or becomes incapable of acting, or the client changes his advocate as notwithstanding the agreement, he shall be entitled to do any party or the legal personal representative of any party to such agreement may apply by chamber summons to the court to have the agreement set aside or valid, and every such application shall be dealt with in accordance with subsection 2, provided that in the case of a client changing his advocate, the court shall have regard to the circumstance in which the change has taken place, and unless of opinion that there has been default, negligence, improper delay, or other conduct on the part of the advocate affording to the client reasonable ground for changing its advocate shall allow the advocate the full amount of the remuneration agreed to be paid to him. So where a person changes his advocate, it doesn't mean, and if he has acted, okay, okay, and he has performed part of the job that he agreed to perform, okay, to represent the client, he can be granted the full amount, okay. So a client should be well advised while changing advocates, because the advocates are paid their full amount where there has been no evidence of negligence, delay, or what do you call, or malpractice, whatever. Mm. So Subject to this section, the cost of an advocate in any case where an agreement has been made by virtue of this section shall not be subject to taxation. The cost of an advocate in any case where an agreement has been made by virtue of this section shall not be subject to taxation. Okay. Now, section 46, invalid agreements. Nothing in this act shall give validity to any purchase by an advocate of the interest or any part of the interest of his client in any suit or other contentious proceeding. So this is about invalid agreements. Nothing in this section in this act shall give validity to any purchase by an advocate of the interest or any part of the interest of his client in any suit or other contentious proceedings. So it's not advised for an advocate to purchase the subject matter of the suit or to have to own any or any part or the whole of any interest of his client. Okay. Any agreement relieving any advocate from responsibility for professional negligence or any other responsibility to which he would otherwise be subject as an advocate. So you cannot claim indemnity, not indemnity, like immunity from professional negligence. Maybe have your client sign some document in the beginning stating that you cannot sue him, in case of any reason. You cannot take him before the complaints commission or something like that. Any agreement by which an advocate is retained or employed to prosecute or defend any suit or other contentious proceedings stipulates for payment only in the event of success in such suit or proceeding, or that the advocate shall be remunerated at different rates according to the success or failure thereof. So also you cannot, as an advocate, enter into an agreement with your client saying that you will only accept payment if you succeed or you win the case, and if not, then maybe he'll give you only half payment or part payment. It's not allowed. It's not a valid agreement. Only agreement by which an advocate agrees to accept in respect of professional business any fee or other consideration which shall be less than the remuneration prescribed. So this is undercutting. No agreement for undercutting is valid. Also, in the same way, where you overcut, if there's such a word, where you enter into an agreement with the client for any fee or consideration which shall be more than 25% of the general damages recovered, less the party and party cost as taxed or agreed. So you also cannot take more than 25%, okay, of the damages less the costs, okay. Any disposition, contract, settlement, conveyance, delivery, dealing, or transfer that is under the Insolvency Act void or ineffective against the official receiver or a bankruptcy trustee or an interim trustee in proceedings under that act. Okay, so you can see what Section 46 is considering as invalid agreements. It comes to mind undercutting, overcutting. Those are obvious. Then those that where you, as an advocate, you're interested in the property of your client, which is no. Because remember, as an advocate, you have the original title deeds, you get all the information of the clients, the ID. Who is to say you are not going to sign yourself, for example, a specific power of attorney that is not revocable, and you control the property of the client. Who is to say, because you have a bargaining power more than the client, so there's no way that any agreement that you're going to purchase maybe his land or anything, or get any interest, is gonna be allowed, okay, under the law. It's not. And we have had cases where lawyers run away with the property of their clients, because you see they're in a position of power there. They know the law, they know how what is required, they have access to the original title documents. Anything that can happen, they can do it if they decide. That is why professional ethics is also very important, and is part of the training in Kenya School of Law, because we need to be trained as lawyers so we don't turn to become criminals out there who have been trained, trained criminals who know the law. So lawyers can be the worst criminals if a day so comes they decide to commit a crime, because they know how to get away with murder. They know how to get away, and they know the loopholes. They know they have access to information and confidential client information. They have access to their title documents for property and this. So it's very important here. It can't be emphasized enough. So that is why it's important that there should be some overseeing power here under Section 47, which is the court. The power of the court to order an advocate to deliver his bill of costs, to deliver deeds, titles, or any documents and papers in his possession. So where a client is feeling like the advocate has retained illegally his original documents and papers, he can apply to the High Court for an order that is going to have the advocates be called upon and produce those documents. So that is under Section 47. Because of the power, the immense power lawyers have been granted, okay, the power to be custodian of sensitive information of their clients, of confidential or original documents, the power to know the law, to know what to do, how to get away with this. So it's very important that there should be some other prefect, or monitor who can have overriding power and can order the advocate to account for his actions, to show himself, to produce the documents, to show the bill of costs. So it's very important. So you can see. So Section 47, power of court to order advocate to deliver his bill and to deliver a deed. Yeah, we said that. So for Section 48, action for recovery of costs. Subject to this act, no suit shall be brought for the recovery of any cost due to an advocate or his firm until the expiry of 1 month after a bill. Okay? So you can't bring a suit for the recovery of any cost due to you as an advocate or your firm until the expiry of 1 month after a bill for such cost, which may be in summarized form signed by the advocate or a partner in his firm, has been delivered or sent by registered post to the client, unless there is reasonable cause to be verified by affidavit filed with the plaintiff for believing that the party chargeable therewith is about to quit Kenya or run away from the local limits of the court's jurisdiction, in which event action may be commenced before expiry of the period of 1 month by way of affidavit filed with the plaintiff. So where you, as an advocate, your client refuses to pay you after you can't bring any action, you can't sue them, okay, unless you wait 1 month. Unless 1 month is over after you have given them that opportunity to pay, or you have given them, what do you call it? You have sent them your fee note, okay, signed by the partner of the firm, by the advocate or a partner, and delivered by registered post to the client. So unless you have waited 1 month, you can't sue your client for failing to pay. By way, you can do it by affidavit, by a plaintiff verified with affidavit that is showing reasonable cause, where there is where you can say that the party therewith is about to run away from Kenya. So where the client is running from the local jurisdiction, local limits of court jurisdiction, or is traveling to Tanzania to avoid paying you, in which event action may be commenced before the expiry of 1 month. So this gives recourse for lawyers, advocates who also have been facing problems in the real world, where they have represented clients, but the clients have refused to pay them. So you can sue them by way of plaint with a verifying affidavit, and in your plaint you show cause if it is before one, excuse me, if it's before the expiry of 1 month, you show cause as to maybe they're running away from Kenya, or they're trying to run away to avoid paying you. All right. So remember, advocates are taxed from their income, the fees they get paid by their clients. So you will be taxed whether you have been paid or not, which is serious, because now, how do you get taxed serious and you've not been paid? There needs to be serious measures put here for clients, okay, to pay. I don't know. That agreement that was talked about, I don't remember the section. The agreement you are allowed to have with your clients, was it section 45? Yeah, section 45, agreements with respect to remuneration, where it was held that you can get into a written and executed agreement with your clients about costs of the suit, okay, of representation. So maybe you should be in that agreement, to be safe. But then there must be some security fashioned, okay? There must be some kind of security. An order made under this section may authorize and regulate the taking by an advocate from his client of security for payment of any remuneration to be assigned by taxation, that is under section 44, which may become due to him under any such order. Yes, so the remuneration order is the order that allows for taking, prescribes for taking of security. Let me just write it here so I don't forget. I will check this. Remuneration order allowing for taking of security for payment advocate fees. Alright, so that is section 44, Advocates Act, remuneration order. Now let's move on. Um, so it's very advisable to follow the remuneration order because you can take security, for payment. The order maybe explains. I don't know, but I will find out. Oh my god, excuse me. I'm so healthy, wealthy, placed, and wanted. Thank you. Now, moving on. Let's do this here. Now, so action for recovery. Action for recovery. Action for recovery is action for recovery of fees of an advocate's plaint, verifying affidavit. Section 25, action for setting aside retainer agreements, signed by way of chamber summons. By way of chamber summons. Ouch. By way of chamber summons. So that is that. Okay. Moving on. Moving on. Moving on. Now, section 49, procedure in action Procedure in action where quantum of cost is challenged by defense. Where, in the absence of an agreement for remuneration made by virtue of Section 45, a suit has been brought by an advocate for the recovery of any cost and a defense is filed disputing the reasonableness or quantum thereof, no judgment shall be entered for the plaintiff except by consent until the costs have been taxed and certified by the taxing officer. Interesting. So where a client doesn't pay up and the advocate sues them and there's no agreement for remuneration, okay, made under Section 45. So and the client files a defense saying the amount is unreasonable. What the advocate is asking for is unreasonable. No judgment shall be entered for the plaintiff, that is for the lawyer, except if there's consent, except if the client consents to pay that amount until the costs have been taxed and certified. So the costs have to be taxed and certified by the taxing officer. And this thing of taxing is very discretionary because the taxing officer can reduce the amount if he sees fit. Okay, so that is very crucial. Unless the bill of costs on which the suit is based is fully itemized, the plaintiff shall file a fully itemized bill of the cost within 14 days from the date of service of the defense, or such further period as may be allowed by the court, and shall serve a copy thereof on the defendant. And if the total amount of such bill exceeds the amount sued for, the prayer of the plaintiff shall, subject to the court's pecuniary jurisdiction, be deemed to be increased accordingly, and all consequential amendments to the pleadings may be made. So, where the lawyer claims to be paid, he has to show a bill of costs. Okay, he will file a fully itemized bill of costs within 14 days after filing of defense, after the date of service of the defense, and he is going to show the items which he is claiming to be paid for the service he rendered, if he wrote letters, if he perused them, if he filed, if he traveled to attend court, if he attended court, if he drafted pleadings, if he drafted sale agreements, all those things. He will indicate, and the prices, okay, the prices as per the order for them. No court or filing fee shall be payable on filing a bill of costs required by this section, but if thereby the amount for which judgment is paid in the plaint is deemed to be increased, the plaintiff shall pay to the court such court or filing fees may be appropriate to the increase. So that is self-explanatory. At any time after the bill of costs has been filed and before the suit has been set down for hearing, any party to the action may take out a summons for directions as to whether such bill should be taxed by the taxing officer before the suit is heard. Okay, so the taxing of the bill, of course, is to favor obviously the client, because the taxing officer has discretion to decide whether a price is too high or it should be lowered. Okay, so yeah, or whether to grant the lawyer some costs that he's claiming, or whether those costs are reasonable. Say, for example, you take a helicopter uh, to like those exaggerated or extravagant transport means to attend court, such things like that. Now, Section 50, taxation on application of third parties, beneficiaries, and a trust. Section 50, taxation on application of third parties, beneficiaries, and a trust. So where a person other than the person who is the party chargeable with a bill of cost is liable to pay the bill either to the advocate or to the party chargeable with the bill, or where a person is interested in any property in the hands or under the control of a trustee, executor, or administrator, out of which property the trustee, executor, or administrator has paid or is liable to pay the bill, that person or his administrators, executors, or assignees may apply to the court for an order for the taxation of the bill, as if he were the party chargeable therewith, and the court, having regard to the extent and nature of the interest of the person, may make any order their own which it would have been competent to make if the obligation had been made by that party. So where there's a third person who is gonna pay the bill, of course, on behalf of the client, okay, the person can request for taxation of the bill of costs, okay. Okay, general provisions as to taxation. Every application for an order for the taxation of an advocate's bill or for the delivery of such a bill and the delivering up of any dates, documents, and papers by an advocate shall be made in the matter of that advocate. The certificate of the taxing officer by whom any bill has been taxed shall, unless it is set aside or altered by the court, be final as to the amount of the cost covered thereby, and the court may make such order in relation thereto as it thinks fit, including, in a case where the retainer is not disputed, an order that judgment be entered for the sum certified to be due with costs. Okay. The certificate, yeah. So where a taxing officer has taxed a bill, he provides a certificate, okay, showing that the bill has been taxed, and that certificate, unless it is valid, will be final as to the amount of the cost covered. So the taxing officer arrives at the final cost or fees to be paid, and that amount is final unless it is changed by the court. And the court may make such order in relation thereto as it thinks fit, including in a case where the retainer is not disputed and an order that judgment be. So where there's a retainer and it's not disputed, the court can give an order that the judgment be entered for the sum in the retainer with costs. Now, charging orders. Any court in which an advocate has been employed to prosecute or defend any suit or matter may at any time declare the advocate entitled to a charge on the property recovered or preserved through his instrumentality for his tax cost in reference to that suit or matter, and may make orders for the taxation of the cost and for raising money to pay or for paying the cost out of the property so charged as it thinks fit, and all conveyance and acts done to defeat or operation to defeat that charge shall exceed in the case of a conveyance to a bona fide purchaser for value without notice before it is against the advocate. Any court in which an advocate has been employed to prosecute or defend any suit or any matter at any time declare the advocate entitled to a charge on the property recovered or preserved through his instrumentality for his tax cost. So, for example, where the client doesn't have money, for example, to pay the lawyer, okay, the court can order that the lawyer is entitled to a charge on the property of the client. That is what I got from this. I don't know if it's wrong or right. Uh, Now, let's go to part 10 of the Act, Complaints Commission. The Section 53, Establishment of Complaints Commission. So the Complaints Commission is Section 53, Complaints Commission. We know that this Advocate Act establishes a Complaints Commission. The Complaints Commission is an entity established by the Advocates Act under Section 53 to hear complaints brought by clients about advocates or against advocates who have acted maybe who have been negligent, who are liable for professional misconduct, who withdrew client funds and spent them, who misappropriated client funds, who were incompetent, who failed to deliver services, who failed to communicate with or update their clients. There's so many things that an advocate can be found guilty of and a client can complain. Now the website for this, just a minute. The website for this is called what? Let me just find it, please. The website for Complaints Commission. Now, it is it's under the Office of the Attorney General, statelaw.go.ke, Advocates Complaints Commission. We also have their own. Do they have their own website? I remember they had their own things. Let me just get this book. kind of far. Okay. So let me just read through here because yeah. So yes, the website is www.acc.go.ke. That is where you find a form that you can fill. Let me just look for this. www.acc.go.ke. Okay. Wait. No, why it's not coming up? Okay, maybe I got the wrong website, but if you Google Advocates Complaints Commission Kenya, you will find this. It opens up on an LSK State of Kenya website page. So there is so it opens up on the website of Kenya and explains, and then there's a link that you can fill like a complaint box where you enter your name, your last name, your email address, your phone number. You indicate whether it is a compliment or a complaint, and you write here what the complaint is about, and then you submit. But really, I thought this was more than that. The help form. I wonder where this help form. There's normally a help form. So help form, Advocates Complaints Commission. Commission Kenya. Yeah, so this one opens up on statelaw.go.ke under the Office of the Attorney General. Let me see. So the help form. Okay, here, okay, it opens and says that it says when you open the statelaw.go.ke department, it's a department under State Law Office, Advocates Complaints Commission. It opens up and there's this guy, Mr. George Nyakundi, Secretary of the Advocates Complaints Commission. And the commission, it says, is responsible for investigating complaints against advocates, undertaking reconciliation of the parties, referral of complaints to the disciplinary committee, and prosecution of disciplinary actions before the disciplinary committee. So they are the prosecutor as well as the referral, because they receive the complaints, then they draft the charges and send them over to the disciplinary committee, okay, on behalf of the client. You understand? So they ask you, do you have a complaint against an advocate? Then they say, click here to see how we can assist you. Let me just click and see what it gives. Okay, then it says we receive and inquire into complaints made by any person regarding the professional conduct of any advocate. Okay, firm of advocates in matters such as advocates withholding a client's fund. So where an advocate withholds the money of a client and doesn't give it to them, or when advocate, fails to attend court on behalf of a client, where he fails to update a client, as I told you, on the status of the case. Neglect of a client's case, where they neglect the duties, compromising a client's case without their consent. Okay. Now, our main objective is to promote professional discipline in legal practice and administration of justice. So that is the main objective, professional discipline. So their objective is to promote professional discipline in legal practice. Okay. Process of filing a complaint. So here they tell you how to file a complaint, receive complaints and conduct investigation, promote reconciliation and provide an amicable settlement, educates the public to know their rights in advocate-client relationships, refers and prosecutes complaints of professional misconduct, advise status of advocate professional standing. Our mandate to receive and conduct investigations into complaints of professional misconduct against advocates, firms of advocates, and their employees. We promote reconciliation and facilitate amicable settlements between advocates and clients that are not serious or can be settled with ADR. We refer and prosecute complaints of professional misconduct before the advocate's disciplinary tribunal to conduct public education and awareness programs that empower the public on their rights. So they conduct public education and awareness programs that empower the public on their rights and obligations. So they conduct awareness. We offer advice on status of advocates professional standing when seeking employment in public service or provision of legal services to the government. Mm. So if you want to know the history of an advocate, whether he is good to go or he is been struck off, you can go here and apply for their status. For more information on this service, visit the Advocates Complaints Commission website. Okay, let's click on that. Okay, yeah, so I was right about the name of the website before, www.acc.go.ke, but upon clicking on that link provided, it reads this site can't be reached. It might be temporarily down or it may have moved permanently to a new web address. So that is that. Unfortunately, you can't help but feel. Where can we find the form? The help form that you're supposed to fill, and you state the advocate you're complaining about, their name, address, phone, office, relationship, whether you have paid fees, is he senior or associate, whether you raise the complaint to the advocate first, whether you're declaring it as truth. Yeah. So this is what the Advocates Commission does. So I think we have learned those things we need to learn. So the president normally appoints the commission in this commission. That commissioner has the same qualification as a judge of the High Court. The commission may require a person whom it considers necessary for the purpose of carrying out its duties to assist it in so doing. Anyone who fails to cooperate is guilty of an offense. So he will receive, the commission will receive, consider complaints, any advocate or firm of advocates, or any member of the firm or employee. It can reject the complaint where there is no substance. So where it says that the complaint constitutes a disciplinary offense, it will refer it to the disciplinary committee, which is the disciplinary tribunal. If it appears to the commission that there is substance in the complaint but it does not constitute a disciplinary offense, it shall notify the person or firm who is complained against and call them to come and answer the complaint. After the expiration of the period specified, the commission shall proceed to investigate the matter, for which purpose it shall have power to summon witness. So the commission has powers of the court to summon witness, to require production of evidence, examine witness on oath, and all those other things. So the commission normally promotes reconciliation and amicable settlement where the matter is not serious. Where the complainant suffered loss or damage, commission can order compensation not exceeding 100,000 shillings. So they have a limited compensation of 100,000 shillings. Mm, mhm. So let's just so an order made under subsection 6 of compensation can be registered with the court. So the court registers any orders the commission makes, so they can be enforceable. Okay. The commission can also order the surrender of funds to the client or property. And the advocate has recourse to appeal. The person can appeal to the disciplinary committee for a review of the order. So there's a hierarchy here from commission to the disciplinary tribunal. Okay. Oh, I'm so blessed. Thank you. So The Commission may, in hearing a complaint against an advocate, order such advocate to produce to the Commission a detailed fee note for purposes of taxation of the bill of costs. The Commission may investigate the account of an advocate against whom a complaint has been made and can order for the advocate to produce all the documents necessary. They can also attach property of the advocate, okay? Yeah, they can issue a warrant of attachment and sale of advocate's property or farm property. Any party aggrieved by a decision or order of the Commission under this section may appeal to the High Court, and the determination of any such appeal shall be final. Okay? So you can see all these wonderful things here taking place. So there's a hierarchy. From commission, you agree, you review. You apply for review of the order to the disciplinary tribunal. Oh, excuse me. And if that's also and you can also apply to the High Court, which determination will be final. The Commission shall publish a quarterly report as to the complaints dealt with by it in the quarter, and the report shall be made in such manner and be in such form as shall be prescribed by rules made under subsection 3. Okay, so the Commission is supposed to publish a quarterly report as to complaints dealt with it by it in that quarter. But we see that we can't even access their website. Their website www.acc.go.ke is inaccessible. How can we see the, what do you call the what? How can we see their what? Their reports for complaints. Oh, yeah, it's not opening, unfortunately. I don't know what is wrong. I think something is wrong with the website. So, moving on, remuneration of commissioner, salary, allowance, pension. Yeah, Parliament pays the commissioner. The money, the salary is determined by the president because the president appoints the commissioner. Now, section 54, secretary and staff of commission and rules. Do we really need to know this? There is a secretary who is appointed by AG. Official exercise the duties. There's so many rules. Okay. Oh my God. Because the president appoints, the AG is representing him in this capacity. What else? Discipline. Part 11, discipline. Section 55, advocates to be officers of court. Every advocate and every person otherwise entitled to act as an advocate shall be an officer of the court, shall be subject to the jurisdiction of the court and to that of the disciplinary tribunal, provided the person mentioned in section 10, like the prosecutor, police prosecutors, those who are not advocates but can act as advocates, provided the AG or the DPP appoints them, will not be subject to the jurisdiction of the tribunal. So all advocates are subject uh, to the jurisdiction of the disciplinary tribunal. Now, Section 56, savings of disciplinary powers of court. Nothing in this act shall supersede, lessen, or interfere with the powers vested in the Chief Justice or any of the judges of the court to deal with misconduct or offences by an advocate or any person entitled to act as such, committed during or in the course of or relating to proceedings before the Chief Justice or any judge. So it means that the existence of the disciplinary tribunal does not exempt the jurisdiction of the High Court or the Chief Justice to deal with offences of professional misconduct by advocates. Now, Section 57, Establishment of Disciplinary Tribunal. There is established a tribunal to be known as the Disciplinary Tribunal, which shall consist of the Attorney General, the Solicitor General, or the Deputy of the Attorney General, someone deputed by Attorney General, and 6 advocates. Wow, so this is really serious. You are facing the Attorney General, 6 advocates, other than the chairman, vice chairman, or secretary. 6 advocates of 10 years or more, okay, experience. Wow. So now, what are the proceedings like in a disciplinary tribunal, Section 58? The proceedings before the tribunal be constituted, the panel can be constituted of either 3 or 5 members. The Attorney General or his deputy, Solicitor General, or his deputy are supposed to be there. They will preside over all the meetings. The secretary of the society shall be the secretary of the tribunal. So the secretary of the society shall be the secretary of the tribunal, and his remuneration, if why are we talking of remuneration? Yeah, that's not important. So the tribunal, just like the commission, can administer oaths and affirmations, complaint and the advocate to whom a complaint relates, and an applicant making an appeal to whom may take out a summons to give evidence or to produce documents, but no person shall be compellable under any summons to produce any document which you could not legally be compelled to produce in a trial, in a normal trial. All proceedings before shall be deemed for the purpose of chapter this 9 of the chapter 11 of the Penal Code to be judicial proceedings, and for the purposes of the Evidence Act to be legal proceedings. Alright, so the tribunal may close for regulating the making of the tribunal and the hearing and determination by the tribunal of all complaints under it. Now, then we have under section 58A, establishment of regional disciplinary committee. Okay, so we can see out we have so many disciplinary. We have, first of all, we have section 53 complaints commission, section 57 disciplinary tribunal, then we have section, what do you call, we have now this one, a new regional 58A regional disciplinary committee. Disciplinary committees. Okay, they are hereby established disciplinary in 5 representative regions other than Nairobi, identified by the Law Society of Kenya. Each regional disciplinary committee shall have a jurisdiction concurrent to that of the disciplinary committee established under section 57 of the Advocates Act. In their respective regions and shall exercise the same functions and have the same powers and duties as set out under this part or under any written law. So, the difference between disciplinary tribunal and disciplinary committee is that disciplinary committees are regional, like they are broken up, because the disciplinary tribunal with the AG, the state law office, that means it is based in Nairobi. So this is like Nairobi, and this is 5 other regions other than Nairobi. Okay, for easier access, and they will have same powers. You see, they have the same powers. Functions and powers. Each shall have a concurrent. They have a same jurisdiction of the disciplinary tribunal. Advocates, they have 5 advocates, not less than 10 years, it's the same. The provisions shall apply to the committee, and the 2 shall be used in general where difference is not to 1 or in any other written law. Application for removal of name from the role of advocate, that is section 59. An advocate may make an application to the tribunal to procure his name to be removed from the role. So an advocate can say, I don't want to be included. I don't want to be an advocate anymore after working so hard and taking all those exams. Someone can apply to be removed from the role of advocate. So that is under section 59, application for removal. They can make an application to the tribunal, that is the disciplinary tribunal, to procure his name to be removed from the role. On the hearing of an application under subsection 1, the tribunal may make an order that the name of such advocate be removed from the role and may make such other order in relation to the case. So applications to be removed from the role are made to the disciplinary tribunal. Okay, just note this down. Okay, so the application to remove yourself from the role of advocate is made to the disciplinary tribunal, okay, and they will grant it. Section 60, complaints against advocates. Now, a complaint against an advocate of professional misconduct, which expression includes disgraceful or dishonorable conduct incompatible with the status of an advocate, may be made to the tribunal by any person. So, where you have a complaint against an advocate of professional misconduct, which is defined as disgraceful or dishonorable conduct. So section 60 defines professional misconduct as dishonorable conduct unbefitting, okay, of the status of an advocate. Where a person makes a complaint under subsection 1, the complaint shall be by affidavit by himself, setting out the allegations of professional misconduct which appear to rise on the complaint to the tribunal, accompanied by such fee as may be prescribed by rules made under section 58C. So it comes to me that a person has two options. They can either go to the complaints commission, who will either try to resolve the matter before having it referred to the disciplinary tribunal on behalf of the client, or the client can simply directly go to the tribunal. Yes, can directly go to the tribunal and apply, and submit his complaint by way of an affidavit, setting out the allegations of professional misconduct. Yeah, so that is what is coming through for me. So it's like the complaints commission is like that detour you can go on your way to complain, like you are open to negotiation where the matter is not so serious, you are open to settlement. But the one who goes directly to the tribunal with an affidavit and sets out the allegations is the one that is very serious, okay, about punishing the advocate. So on the complaints, two ways. One way is to ACC, another is to DT. DT is by way of an affidavit setting out your allegations of professional misconduct. Okay, you will pay a fee. There's a fee that you pay. Now, where a complaint is referred, Now, where a complaint is referred to the tribunal under Part 10 or subsection 1, the tribunal shall give the advocate against whom the complaint is made an opportunity to appear. So, of course, it's just like in a trial where you are being complained against, you are called to appear and answer to the charge, okay? And shall furnish with a copy of the complaint and of any evidence in support, shall give him an opportunity of inspecting any relevant document not less than 7 days before the date fixed for the hearing. Yeah. So the person is called to answer. They're given the complaints, they're given the documents, so they are aware of the allegations being made against them, okay? And they're given at least 7 days before the date for hearing is set, so that they have an opportunity to peruse, to ask for more information, to inspect any documents. Uh, where now the complaint does not disclose any prima facie case of professional misconduct, it can be rejected, okay? It can be dismissed without requiring the advocate to come and answer. After hearing the complaint, the advocate, if he wishes to be heard and considering the evidence, the tribunal may order that the complaint be dismissed, or if of the opinion that a case has been made, the tribunal can order that such advocate be admonished. So the orders that the tribunal can give include the orders they can give can be the order of the advocate can order dismissal of complaints if there's no case, okay? It can also order for the advocates be admonished. I don't know what admonished means. Let me check. Admonished. Yeah, admonish. So it means warn or reprimand firmly, advise or urge earnestly, warn someone. So admonish means they can be warned, okay? Admonish uh, can be suspended, so suspension, but the suspension should not be not more than 5 years. Okay, they can be struck off the roll of advocates, can be ordered to pay a fine, but not more than 1 million shillings. They can be compensation, so they can be asked to pay compensation to the aggrieved client, not exceeding more 5 million, or a combination of them, of the so you can see clearly here the orders that can be given are of a serious nature, ranging from, of course, being warned and all the way to other serious orders like payment of compensation, being struck off the roll, or paying fine, or being suspended. The tribunal may make any such order as to payment by any party of any cost of witness statement and witness expenses, and of the expenses of the tribunal or the members thereof in connection with the hearing of any complaint as it thinks fit, and any such order may be registered with the court, and shall thereupon be enforceable in the same manner as an order of the court. So there are costs to be paid to the commission, to the tribunal that is sitting to hear the matter, and any such order may be registered with the court to make it enforceable. Where an advocate against whom the tribunal is hearing a complaint relating to fees and costs has not filed a bill of cost, the tribunal may, upon the request of the complainant, order such an advocate to produce before it a detailed fee note. And the tribunal has power to determine the fee payable to the advocate, okay, as it deems fit, where there is no fee note filed. If a bill of cost has been filed in court by the advocate, but has not been taxed, the tribunal may adjourn the complaint to allow the taxation, provided that at the expiry of such adjournment, the bill is not taxed, the tribunal may make its own estimate. A determination of the tribunal under subsection 7 and 8 shall be deemed for all purposes to be a determination of the court. So it's very serious that the tribunal has powers of the court uh, to determine or even estimate what the advocate is supposed to get paid. In any case where the complainant has not filed a civil suit against the advocate in respect of the sum in dispute, the tribunal may order the advocate to pay to the complainant such sum as it finds to be due from the advocate, okay? An order made by the tribunal under this section shall be in the name of the advocate or firm of advocate in respect of whom or which the order is made, may be filed in the civil registry of the court by any party who shall within 21 days of the filing give a notice to all other parties in writing of the filing of the order, which shall bear the date, the cause number, and the registry in which it has been filed. If no memorandum of appeal is filed in accordance with subsection 1 of section 62, the party of whom the order is made may apply ex parte by summons for leave to enforce such order as a decree, and the order may be executed in the same manner as an order of the court to the like effect, and if it is an order for the recovery of money, may be enforced on the immovable and movable property of the advocate in accordance with the civil procedure rules. The tribunal may issue a warrant for the levy of the amount of any sum ordered to be paid by virtue of this section on the immovable and movable property. So they can issue a warrant for attachment. Now, so that is basically what they can do. Whatever order is made can be registered. Is made can be filed in the civil registry of the court by any party thereto who shall within 21 days give a notice to all other parties in right. So it is filed in the court. So, and if no memorandum of appeal is filed, if no memorandum of appeal is filed in accordance with section 1, The party in favor can apply order, can apply via chamber summons, ex parte, may apply ex parte by summons for leave to enforce such order. For leave to enforce such order, okay, as a decree. So the order will just be like a decree, and in the decree you can ask for help, whatever you can ask for to be helped with issuance of warrants of attachment to property of the lawyer or the firm, to property of the lawyer, okay, where there is payment that is required, okay. The tribunal can also issue what we call the warrant of attachment, okay, on property of the advocate. Now, Section 60A, hearing of complaints. The powers conferred on the committee by this section may be exercised on the hearing of any application or complaint made to the committee under this Act by or on behalf of the Council, any application made to the committee by the Complaints Commission under this Act, or any application or complaint made to the committee under this Act by or on behalf of any person. So, any appeal against order of tribunal, any advocate aggrieved by order of the tribunal made under Section 60 may within 14 days. So, a person can appeal within 14 days. Appeal against order of tribunal. So, appeal against order of tribunal. Any person within 14 days. 14 days. The day of receiving the notice of registered notice of the filed order may may appeal against the order to the court by giving notice of appeal to the registrar, may appeal to the High Court and give notice of appeal to the registrar of the High Court and shall file with the registrar a memorandum setting out his grounds of appeal within 30 days after giving by him of such notice, and shall file memorandum of appeal within 30 days after giving of such notice of appeal. Okay. The court shall set down for hearing any appeal filed, and subsection 1 shall give to the counsel of the instruction to the advocate not less than 21 days notice of the date of hearing. An appeal under this section shall not suspend the effect or stay the execution of the order appealed against, notwithstanding that the order is not a final order. So an appeal under this section shall not suspend the effect of the order made or stay. Okay. Ordinarily, when you want to stay proceedings or stay the execution of a judgment, it's not automatic. You have to apply for stay. I don't remember what application you use. Is it a notice of motion or a different stay application? But you have to apply for stay. You file the application for stay at the same time as you are filing your memorandum. This one is really not. Okay, so moving on. It's very interesting. Okay. So then we have the right of appeal to Court of Appeal. Any advocate aggrieved by a decision of the High Court can go and appeal to the. So a Court of Appeal, any advocate can appeal further at the Court of Appeal. Yeah. Okay, we are done. Okay, that was the Advocates Act. I hope you have learned something. I hope now you know who an advocate is and who is not, who is qualified to act and who is not, what disciplinary measures the Act has given us, how to lodge complaints with the SEC, with the disciplinary tribunal, the powers, the orders they can give. If given an order, what to do to make the order enforceable by filing it with the civil registry and giving it to the lawyer, okay, and from there execution of the decree just like normal decrees and having warrants of attachment on property of the lawyer and so on. Okay, bye, thank you.